So hi everyone, welcome back to Mike's Minutes. My name is Mike Dunn, a wealth advisor with IPC Securities. As I've mentioned in many videos, the purpose here is to educate my audience on important financial topics. Today it's my pleasure to have once again Raluca, a wills and estates lawyer here in the GTA, back for another wonderful episode of Mike's Minutes. Raluca, thanks again for joining us today.
Thank you for having me again. And it's
Anytime.
always a pleasure.
It's always nice to have a lawyer, especially when we don't get sent a bill. So today's topic is on the changes to estates law. But before we get into it, you know the drill. I want to remind everyone that the purpose of these videos is just to provide education and not advice, and everyone's situation is different. Which is why it is always best to reach out to professionals when it comes to these important topics in your life. So like the financial industry, the legal world is ever changing, and it's always beneficial to be updated on important changes. Since the pandemic, a lot of individuals are re-examining their estate and making necessary changes. So if you have not looked at this part of your life in a while, it's never too late to have that conversation with a professional. So with that said, Raluca, you want to go over some of the changes that have taken place in your industry?
Sure, it would be my pleasure. So the first change I want to address is a change to intestacy law. So an intestacy occurs when a person passes away without a will, or they have a will, but the will doesn't address their entire estate, and part of it ends up being distributed on an intestacy. So whenever there's an intestacy, the Succession Law Reform Act provides a framework for the distribution of the deceased assets. So where the deceased left a spouse behind, and it used to be a married spouse, this person would be entitled to something called a preferential share, and the share was 200,000. So the first 200,000, the spouse would be entitled to it, and the rest would be divided between the spouse and the children. So if there was one child, it would be divided half to the spouse, half to the child. If it would be more than one child, so two or more children, the spouse gets 1/3 and the children get the rest divided. So for deaths occurring on or after March 1st of this year, that preferential share has increased to 350,000. So now the spouse automatically gets the first 350,000. So that means that there's less left over for the rest of the beneficiaries. And so that's one change that occurred. And the other change, as I mentioned earlier, this used to be for legally married spouses only, and not for common law spouses. So if a person passed away and they left behind a common law spouse, and then that spouse wouldn't have this preferential share. But the law has been now amended to include common law spouses in this. And for separated spouses, they are now excluded. So even though the deceased could have been married but separated from this person, for the separated spouse is no longer entitled to this, whereas before that was the case, and it's surely not what the deceased intended, to leave their money, a preferential share such as 200,000 to their deceased spouse, but to their separated spouse. So that's changes to intestacy law.
So let me just.
Did you have questions about that?
So like I deal with clients, about many different financial topics of their life. And sorry, my dog is just doing a little cameo in the camera there. And one common thing that I hear is just, I ask them, do you have a will? And, it's like, oh, not yet, or I'm not working on it. So, I don't want people that are listening to this that are in that situation to be like, oh, the courts will take care of my family regardless. Right?
They won't. Then not always. Like now, obviously, this change with separated spouses is a change in the right direction, but it's not always, and it's definitely not distributed as the deceased would have wanted.
Yeah. Yeah. It was interesting. I can't remember if I mentioned this on our or one of our other videos, but like I'm a single guy and I did my will about a year and a half ago, and it was actually a little bit more complex than I thought it would be. And that's like without a family. I mean, you know, I have two older sisters and my parents, obviously. So some of the questions, it's like if one of your sisters predeceases or is deceased and something happens to you, like, do you want the money to go to her husband or to the kids? Like it gets very complex. So,
Yeah.
you know, I always recommend like financial advisors have education pieces on wills and estates, but until I actually went through a lawyer and talked about it and they asked you questions, you know, it's way more complex than I thought. And I was
Yeah.
really happy I did it, right?
Yeah.
Just because there's scenarios that you don't even dream of that
Yeah.
are possible, right?
Yeah. And that's what my clients are telling me too, that they first of all they ask, they're surprised that they have to fill out a long checklist that I give them, and then at the end of the process they come back and they say, okay, now I understand why you had to ask all these questions. As for an estate planner, the worry is always to identify red flags that could impact the estate.
Yeah.
These in terms of in terms of any claims against the estate, but also any possible responsibilities that the estate could have, which have to be addressed in
Yeah.
an estate plan, in a will.
Yeah.
So it's estate planning is a very important part of the process before drafting a will.
Yeah, for sure. I mean, it's never, no matter what you do, it's never 100% perfect, but anytime that you spend, you know, you spend the time with a professional on this, I mean, less can go wrong when an estate is settled. And I mean, I see it in my industry where a family is all great, and then something happens in the family when money becomes an issue and people change.
Yeah.
And you know, it's unfortunate, but that is life. And the more you have documented, especially if you pass away, at least you know you can rest assured that what you want your money to do is going to happen. Because if you don't document that, it may go somewhere you don't want it to.
Yeah. And also on this topic, um, even the things, even if you went to have a will done and you think, you know, your lawyer instructed you at the time based on the law available at the time, you know, the law changes. And as with any, as with a pandemic, a lot of things changed, and the state law changed as well, and the state planning changed as well. So I wanted to also address a few things that affected the estate planning community, and maybe this will affect some of the viewers that are listening, or maybe not, maybe it's good news for them. So one of the biggest changes to estate planning when drafting a will is that it can now be signed remotely. So both the wills and the will and the powers of attorney can be signed remotely. This was not possible before. It had to be done in person. This is good news in that if a person lives in a community where they feel they can find a practitioner that they feel comfortable with, they don't have to restrict themselves to that community. They can find a practitioner anywhere in Ontario to help them draft a will, and they can be signed remotely if the client and the lawyer can't meet in person. And this change was effective as of April 7 of 2020. So lawyers have been hard at work drafting wills for everybody in Ontario.
Yeah,
pretty much.
It's like my industry too. We just, I guess within the last year and a half, have started to adopt e-signatures. And it's like,
Yeah.
you know, back in the day when it's like, you know, I'm going to the bank, or I'm going to see my advisor, I'm going to the lawyers. Now it's like I'm walking to my living room to do that. Right. So
yeah, but for wills, they're actually not e-signatures. Their e-signatures are actually still not accepted. They have to be signed in counterparts, which means the lawyer has a copy of the will and the client has a copy of the will. and they have to be signed contemporaneously at the same time through audiovisual equipment and signed by hand. And once they're signed, and the copies have to be pretty much identical. And once they're signed, the will is sent to the lawyer's office, and the lawyer has affidavits and stamps to put on. So it's a little bit of a different process than regular e-signing, but it is definitely has moved the law forward, which a lot of practitioners are very happy about, that they're able to provide these services to their clients.
So the lawyer, it would, like, the lawyer would document that we, both signed and witnessed, like, with his or her own eyes. Like, it's not recorded and put in a file or anything.
No, I mean, it's not mandatory, but it is recommended that lawyers record this. Okay. And if not, definitely keep notes on the meeting. There's also, side effects to, like with anything, to signing virtually, and sometimes it's not recommended. For example, where there's possibility of undue influence, so somebody influencing somebody to do their will in a certain way, and that person doesn't show on camera, they're behind the camera. So there's more risk, I would say. But generally, it's up to the lawyer to assess the risk, ask the right questions, and then offer the solution for the clients if it's appropriate for the situation.
Yeah, well, that makes sense. It's, nothing's 100%.
Yeah.
I wrote, I have to write the odd exam in my industry. I'm sure you have to do education and so forth, but some of they do allow remote exams, and I don't do the remote exam because you have to, like, give them a 360 tour of your workstation. You're on video the whole time. Like, it's just kind of awkward. So certain things I'm just like, I'll go to the center to write it.
Yeah, which is why actually a lot of clients have preferred to just come and sign in person. And a lot of times I recommend that they come and sign in person because their particular situation, either they don't feel so comfortable with audio visual, and another person has to set it up for them, and then that inadvertently, even if it's not intended, that could lead to undue influence. And so depends. Each client is different, and their needs are different.
Yeah, for sure.
Yeah. So the second biggest change I wanted to talk about is that in the past, and even currently, if you had a will done and executed, and then you get married after doing that, and there's no clause in the will that says that you're doing the will in contemplation of marriage, then the will is revoked. And a lot of people don't know this, and think that they have good wills. For example, a lot of people had lived together common law and prepared wills where they gift each other, they appoint each other executor. Regular couples will, they appoint each other as executors, they gift everything to each other, and following that to children or some other people. But once they decide to get married, both wills are revoked currently. This legislation is supposed to be repealed as of January of 2022. And that's exciting because I've always thought that this is sort of a inheritance of archaic law, I should say, where the law is trying to protect the testator from himself. So if the testator situation changes, then technically they should be doing a new will. Excuse me. And marriage is a significant reason to think about updating your will, because a new person is officially entered your life. Their status is now official as married. And there might be children coming, and so it's a big life change. And I always recommend to my clients that it's one of the points in their life when they should consider updating their will. But the law is changing, and as of January, it's not necessarily the case. However, for people that are getting married January 1st and after, they should still consider updating their will, because in the past, maybe they had another spouse that was just common law and they left gifts to that person, or they, what if, or just any other person, or maybe they left everything to charity. And so that leads to problems. So that's a big milestone, I think, in addressing revocation by marriage and moving the law forward.
I mean, I always say any big material change, you should have at least a review. You know, it's no different than financial situations, right? Like different accounts, like an RSP, they get married, maybe a spousal RSP makes sense, right? So there's a lot of things that need to be discussed, because you know,
changing beneficiaries. Now that you have a spouse, you may want to add your spouse as a beneficiary, because maybe now you have a mortgage. And it makes more sense that your spouse inherits to be able to pay the mortgage and live in the same home, or there's kids and there's so expensive, the cost, there's so many costs, and you know, when they're younger until university and beyond.
Should I have put my dog as my beneficiaries when I got her?
You can't put a pet as a beneficiary, because in Canada they're considered property. It's so like
she would be in my will, but not as a beneficiary. Who gets?
But you can, however, gift to your pets. So you can set up a trust that is administered by somebody who you trust, and you can put money in that trust, and you can direct that person to spend this money on so and so, you know, on your pets, regarding these things.
Possibly buy.
Well, they're just their care. Vet bills can add up if they have a health issue.
True.
Food. People like to know that their pets are taken care of once they pass away, and they
speak of the devil.
Your pet is very active today.
She's not giving me my you know, airtime alone here, but it is what it is.
Okay, I'm sure she's just gonna entertain the more.
Maybe we'll get more views because there's a dog, right? Who knows?
Hey, these things have happened on TV as well.
It could be worse.
News anchors, it could be worse.
That's true. Any more changes that you want to discuss?
Yes. So I wanted to talk about divorce and separation. So the law used to make a clear distinction between the rights of spouses that are married versus the rights of spouses that are, that are married and separated, and spouses that are divorced. So let me make that distinction. So oftentimes the scenario that I read about, and then I warn clients about, and I watch for, is a situation where somebody is still married to a person. They did not get along, they separated. So even though there's a separation agreement, and they now have another spouse that they live with, that is common law, counts as a common law spouse. So technically they have a married spouse that they're separated from, and a new spouse that they live with. So until January 1st of the coming year of 2022, the Succession Law Reform Act provides that on divorce, a spouse, the will is altered to remove the divorced spouse from the will. So any appointments of executor in the will of the former spouse are removed, as if the person has predeceased the testator. That's exactly how this is treated. Any gifts to that person is counted as if
what about powers of attorney? Would that apply as well? Or is that
I don't think so. I'm not sure. I think this is only addressing the Succession Law Reform Act, which addresses the only testamentary dispositions. And so that was a problem, because for people that were not divorced, that's where the problem lay, and they had a new common law spouse that was living with them. The problem was that the spouse that they were not divorced from had, first of all, they were entitled to claim that preferential share I outlined earlier. And second of all, they're still entitled to anything under the will. But as of January 1st of 2022, separated this section of the Succession Law Reform Act is enlarged to include separated spouses. So it expands to include separated spouses. So now that situation as of January 1st, 2022 won't be applicable, where somebody is married but separated and they have a new spouse. If they're married and separated, it will still be treated as if the separated spouse had predeceased the testator, which makes a lot of sense.
Yeah, for sure.
I'm pretty sure that somebody, I mean, unless there's a very good relationship between amicable relationship left between separated spouses, usually a new person who enters a new relationship, they have new obligations, they have a new life, they have new commitments, and it makes sense that their new life addresses their new spouse, the common law spouse.
And there might be some people, sorry to cut you off, there might be some people that won't go through the divorce because they want to kind of keep their ties with somebody, they might have money, and they won't let the relationship kind of, be over in hopes that they get something. So it kind of avoids situations like that too.
Yeah.
Interesting.
Yeah, so it makes a lot of sense. And I always thought that this particular provision and the provision where revocation by marriage, I always thought that I always found them funny rules that didn't have a lot of sense to them. But I'm glad to see that the law has expanded and is recognizing blended families and the situation of today's world and today's family,
There's still a lot of room in a lot of industries for that kind of thinking to prevail, right? There's a lot of things even in my industry that I'm like, why is it still like that?
So if you set a beneficiary, for example, for a registered account, there's a beneficiary, and the beneficiary is the spouse. Does it matter if they're separated or not? It doesn't matter, right?
Yeah.
It doesn't make a difference, like separation or divorce. Does that make a difference?
Well, the beneficiary always trumps like the will, right?
Yeah.
So it's like, again, in my industry, if anything material changes, we've got to have a conversation. And now she's throwing toys on the floor. So
she's excited about the changes to these things.
I know, she may be a future lawyer there, I guess. Who knows? But I always say, like, any material changes in life, and that's why it's important to build a relationship with a lawyer, an advisor, because the law does change. Like, there's a lot of tax laws that are changing too, and that matters to how much money maybe an estate will get, or
there's been changes to that too. I don't usually address tax law changes, but there's been changes with respect to trusts and reporting on trusts and taxation of trusts and tax rates for trusts. And to give everybody a hint, it's not in the estate's favor.
It usually is.
Definitely an accountant should be consulted on this too.
Well, maybe we'll have to, there's a ton of topics that you and I and Phil, who's the accountant that we bring on here sometimes, maybe we could have a chat about that. Or maybe even you and I down the road, we could have a full out video on marriage, right? Because there's a lot of confusion. I see it a lot of what a spouse is or is not entitled to, and if something happens to the marriage. So maybe that's, down the road for another video. But yeah, I think, we covered a lot today. I say in every video when I have another professional on here, if there are questions or comments or anything, please reach out to me. I can relay them to Raluca or get you in touch with her. So we'll say goodbye for now today. I want to thank everybody for watching this video. And until next time, my dog's still making noise. Apparently she wants to go out. I hope everyone stays safe, stays healthy, and stays invested. Thanks again for joining us, Raluca.
Thank you for having me.
Take care, everyone.
Take care.